Assalamualikum OyaRahmatullahe OyaBarakatuhu. Innal hamdanillah wassalatu wassalamu ala rasulillah. Amma ba'd. Bismillahirrahmanirrahim. This is Muhammad Kamrul Hussain, Department of Business Administration, Metropolitan University, Sylhet. Welcome to my virtual classroom, MKA Classroom. Now let's start today's video tutorial. Today we will try to discuss dissolution of a partnership. That means an elimination of a partnership business, or the termination of a partnership business. So today we will try to discuss this termination of a partnership business. Dissolution of a partnership means change in a relation of partners by elimination of one. Where the partnership business can be terminated or can be ended by the several procedures, and these procedures are categorized by terminated by the partners, terminated by the court, and terminated by the operation of law. So these are the categories of dissolutions of a partnership. That means how a partnership can be dissolved or how a partnership can be eliminated or can be terminated. So it can be terminated by parties, court, and by the operation of law. At first, we will try to discuss termination or dissolution of partnership by the act of parties. This can be terminated by in three ways. One is agreement, another is withdrawal of funds, another is expulsion. These are the three ways that a partnership can be dissolved by its parties. First one is agreement. If the partners has an agreement or prefixed agreement to terminate this business on a fixed date, then after this date this partnership can be terminated. Or the date is not fixed when it is terminated, but partners are agree, all partners are agree to terminate their business, then the partnership business can be terminated. So that's the agreement. Under the agreement to terminate the partnership business. So if one party propose to terminate, other parties agree with it, then it is again terminated. That's the terminated by parties from the agreement. Another termination is withdrawal. Withdrawal of funds. Withdrawal of funds. The withdrawal of one partner at any time and for any reason unless wrongful historically dissolved the partnership. So basically there is no rules to withdraw fund from the partnership business, but other parties or other partners can support by the withdrawal funds or withdraw his partnership portion, or he can sell his portion to the another parties. So other partners can dissolve this business. So partnership agreement may provide the partnership to continue. There is no prescribed from the withdrawal. A partner can withdraw merely by informing the other partners of the withdrawal. In a partnership for a definite term, any partner has the power but not the right to withdraw at any time. A withdrawing partner has a liability for any loss sustained by the other partners because of the withdrawal. If the partnership agreement does not set a dissolution date, a partner may withdraw at will without liability. After creditors are paid, the withdrawing partner is entitled to receive the capital and distributed profit, repayment of any loans to the partners. In this way, this partnership can be dissolved. And expulsion. The partnership agreement may and should contain a clause providing for the expulsions of a member, especially if the partnership has more than 2 members. This clause should spell out clearly that acts for which a member may be expelled and the method of settlement for such a partner's interest. A partnership may not expel a partner for self-gain. A partnership agreement should also set forth that the remaining partners agree to continue the business upon expulsions of a partner. Otherwise, it might be necessary to wind up the partnership business and distribute all the assets to the creditors and partners, thereby terminating the partnership exercise. That is the expulsions. That means whenever the partners are expelled a partner from their business, that is the expulsions. Other partners can expel one partner from their business, that is the expulsions. And whenever the expulsions can be done, they create the winding up or wind up. So what do you mean by winding up? Actually, winding up is the taking care of outstanding obligations and distributing remaining assets to the partners. That is the winding up. So in this way, partnership business can be terminated by their parties. One is agreement, withdrawal himself from the business, and partner can expel any other partner, or you can call it expulsions. So in these three ways, the partnership business can be dissolved by the parties. Now we will see the partnership business can be terminated by the court decree or court order. So in this system, termination system of partnership business, there has 4 ways to terminate. Number 1, insanity of a partner, that means become mad or lack of sound mind, incapacity, lack of fund, misconduct or misbehavior of one partner, futility, that means a lack of sense or lack of humanity, apadartota. Futility means apadartota. So these are the 4 ways that a court can decree the partnership business to be terminated. Now we will see insanity of a partner. A partner may be obtain a decree of dissolution when a court declare another partner insane or unsound mind or mad. Then we know that in partnership business, any one partner is dead or deceased or insane, then partnership business may be terminated. So here is this matter. If a partner can become insane or become mad, then the court can declare or decree to terminate the business. Then incapacity of a partner. So this will have, if a partner develops an incapacity that makes it impossible for that partners to perform the services to the partnership, that the partnership agreement contemplated or may be failed or may be terminated on that ground. That means if any one partner becomes incapacity to perform the services in the management or contribute to the management to run the business, or has the lack of capacity, then the court may declare or decree to dissolve this partnership business. A member of an accounting firm who goes blind would probably be incapacitated to extent of justifying dissolutions. So here is another good point. If the one partner becomes blind, then it is cannot to run the business by him. So there is the point of incapacity. In this way, it may be dissolved. Misconduct. If one member of a partnership engages in misconduct prejudicial to the successful continuance of the business, the court may, on proper application, decree a dissolution of partnership. Such misconduct include habitual drunkenness, dishonesty, persistent violations of partnership agreement, inconceivable discord among the partners as to major matters, and abandonment of the business by a partner. That means all kinds of misconducts can create the dissolution of the business. So if the partners has the too much bad habit, too much drunk, dishonesty, has convicted the violence relating to the violence, the one partner, then this business firm may be dissolved. Last one, futility. All business partnerships are conducted for the purpose of making a profit. If this objective clearly cannot be achieved, the court may decree dissolution. One partner cannot compel the other members to assume continued losses after the success of business becomes highly improbable and further operation appears futile. A temporarily unprofitable operation does not justify dissolutions. A court will issue a decree of dissolutions only when objective reasonably appears impossible to attain. Then the court can declare or decree to dissolve the partnership business. So these are the 4 things in which court may declare or decree to dissolve the partnership business: insanity of a partner, incapacity, misconduct, and futility. Now, dissolution by operation of law. Now we will see operation of law. In this way, the operation by law, this can be done in three ways. One is death. Death of any one of a partner can create the dissolution of this partnership business. Bankruptcy, any one partner can become bankrupt, or total business may become bankrupt and the business can be dissolved. And illegality, if the business become illegal, then it is automatically dissolved. Under certain well-defined circumstances, a partnership will be dissolved by operation of law. That is to say, it will be dissolved immediately on the happening of the specified event. No decree of the court is necessary to dissolve in the partnership business. These are the example of eliminations of partnership business, that is death of a partner. So if any one partner is dead, then the partnership business is eliminated or dissolved automatically. So here is an opportunity for representative work in lieu of the dead person, but the rules of the government, the business should be dissolved. If there has a representative, then there create another partnership business. Previous partnership business is dissolved. So a representative of deceased may act to protect the interest of the heirs, but cannot act as a partner. That is true even when the partnership agreement provides that the partnership is not to be dissolved by the death of a member. The representative receives the deceased partner's share of the partnership's profit. So that should be depend on agreement. So partnership agreement can provide for an orderly process of dissolutions upon the death of a member. Thus, the provision that the surviving partners shall have 12 months in which to liquidate the firm and pay the deceased partner's share to the heirs is binding. Later one, bankruptcy. Now we'll see bankruptcy. Bankruptcy. People who have their debts discharged in bankruptcy no longer have a responsibility for paying most of their debts, including those connected with the partnership. This destroys the unlimited liability of partners that could otherwise exist, and the partner is not a good credit risk. Because of this, the law regards the bankruptcy of a partner as automatically terminating partnership. So, law regarding bankruptcy of a partner as automatically terminating the partnership. The trustee in bankruptcy has the right to assume control of the debtor partner share of the partnership business, but the trustee does not become a partner. The trustee merely stands in the place of the partner to see the creditor's interests are protected. And lastly, a legality. Some types of business are legal when undertaken, but because of a change in the law, they later become illegal. Then the business can be dissolved. If a partnership is formed to conduct a lawful business and later this type of business become illegal, the partnership is automatically dissolved. So in this way, the partnership business can be dissolved. Thus, we see that this business can be dissolved by partners or partnership business, dissolved by the court decree, and dissolved by the operation of law or immediate dissolutions. So in this way, the partnership business is dissolved. Notice of dissolutions. Notice of dissolutions. So it is another important topic. Notice of dissolutions. That means the partnership business which are going to be dissolved, that business should provide notice to be dissolved, because some parties who have done their business with this partnership firm may not know this type of change. That's why they have several losses. That's why notice of dissolutions provided by the partnership business is mandatory. When a partnership is dissolved, creditors and other third parties who have done business with the old firm may not know the change. For the protection of these third parties, the law requires that when dissolution is caused by an act of the parties, third person who have done business with the firm must be given notice of dissolution. If notice is not given, every member of the old firm may be held liable for this type of act of the former partners that are committed with the scope of their business. A partnership usually gives notice to customers and creditors by mail. It is sufficient to give the general public notice by the publication, such as in a newspaper. When a new partnership or corporation has been organized to continue by the business after dissolutions and termination of the original partnership, the notice of dissolution will also set forth this information as a matter of advertising. If the name of dissolved partnership include the name of a withdrawing partner, this name should be removed from the firm name of on all stationery so that the firm will no longer be liable for the contracts. Only several cases there is no need for notice for dissolve. One is dissolved by the operation of law, when partnership was dissolved by the operation of law, when partnership was dissolved by as a judicial decree, when dormant or secret partner retires. Now, distribution of asset. Distribution of asset. So, after the dissolution of a partnership, the partners share in the assets remaining after the payment of debts to creditors. The distribution of remaining assets among the partners is usually made in this way. Partners who have advanced money to the firm or have incurred liabilities in its own behalf of are entitled for reimbursement. That means whenever a partner has an advance for the firm, this advance can be met up fast. Each partner is the next entitled to the return of the capital that was contributed to the partnership. That means the person who contribute first, he can take share first. Remaining assets are distributed equally unless a provision in the partnership contract specifies an unequal distribution. When a firm sustains a loss, the partners will share the loss equally unless the partnership agreement provides to the contrary. So in this way, the dissolutions assets are distributed. Dissolutions of partnerships firm asset can be distributed. So at first, the advanced money can be met up by the partners. Later on, who is provide contribute first, he can get the first portion, and remaining assets should be distributed equally unless the agreement, there has no agreement.
This all about today. Stay home, stay safe, try to maintain a safe social distance, try to wash your hands frequently in a day. Subhanaka Allahumma wa bihamdika ashhadu an la ilaha illa anta astaghfiruka wa atubu ilaika. Assalamualaikum warahmatullahi wabarakatuh.